Joining us this morning to talk more about the case and what is ahead, Judge Andrew Napolitano, a former New Jersey Superior Court judge. Great to have you. I always look forward to our discussions. I learn a lot. And soon we will be able to not speculate any further about what the evidence and the charges are. But for now, that's where we find ourselves. Some may say 30 plus charges seems like a lot. How would you respond?
Well, good morning, good afternoon. It's the afternoon here on the East Coast. It's always a pleasure to be with you. The 30 charges either mean that every time money was paid by Donald Trump personally to Michael Cohen to reimburse him for paying Stormy Daniels, and every time Donald Trump was reimbursed by the Trump Organization to Trump personally, that each of those was a criminal act. Now, there were 13 payments to Michael Cohen and 13 reimbursements to Donald Trump, so that's 26 right there. That is one way to sort of calculate where they came up with 30 counts. The other way is that there may be other crimes charged here that have nothing to do with Stormy Daniels, that have to do with other frauds in which the Manhattan DA wants to charge Donald Trump as having participated in the past 5 years. We won't know that until the indictment is released. The indictment is a piece of paper on which the charges are outlined. The evidence often is not outlined. Those of us that do this for a living can pretty much, with a fair amount of accuracy, speculate as to what the evidence is once we read the charges. But the indictment will be a sterile document which will just list the charges and what they claim Donald Trump did that was a violation of New York state law.
Explain the statute of limitations in this case and the possible strategy from the defense in relation to that.
Okay, so there's an underlying, that's a terrific question. There's an underlying federal crime here, which is the crime of using corporate funds to pay a campaign debt. That's the crime that Michael Cohen pleaded guilty to. People do go to jail for that. Michael Cohen himself went to jail for 3 years for that. After Michael Cohen got out of jail, the feds decided not to prosecute President Trump. He was out of office already, because they didn't believe Michael Cohen. They believed him when he testified against himself at his own sentencing hearing and guilty plea. They didn't believe he was credible enough to be their chief witness against President Trump. That crime has a 5-year statute of limitations, and that crime occurred in 2016. So the statute of limitations has run. The DA will argue that because Trump renounced his New York citizenship and New York residency and left New York, and also because for 4 years he left New York when he lived in the White House, that the statute of limitations was told, as we say, meaning stopped running for the time that he was outside the state. That is an argument that prosecutors often make, and it is an argument that courts often accept. Look, if the statute of limitations has run, if that underlying federal crime can't be used, then I don't know what they're indicting him for. But if the statute of limitations has not run because he was out of state during most of that time, then they have their case.
That's interesting. Is the judge in a tough spot here with the gag order on the table and some First Amendment concerns?
You know, I can tell you from having been there, not a case this dramatic and this much public interest. However, judges are loath to impose gag orders because of the First Amendment. The First Amendment says Congress shall make no law abridging the freedom of speech. Today, that means no government, local, state, or federal, executive branch, judicial branch, or judicial branch, shall interfere with the freedom of speech. So courts are loath to do that. They will do it if they believe that the defendant's speech is undermining the government's right to get a fair trial. If the defendant is so polluting the jury pool that it will make it nearly impossible to choose 12 jurors, not 12 people that never heard of the case. You don't want ignoramuses, but 12 people who still have an open mind about whether the defendant is guilty or not guilty. So I don't think you're going to get a gag order today. But if the former president goes on a rampage, as we know he can, and begins to argue his innocence in public rather than in a courtroom, you may see some sort of a limited gag order. And I have to tell you, that is the defense counsel's biggest fear, because we all know the president. I'm privileged enough to have been his, and to still be his friend for 37 years. You don't have to know him personally to know he is impossible to silence when something gets under his skin. So if I were Joe Tacopina right now, I'd be saying Hail Marys that no gag order, even a limited gag order, comes down.
Or apparently Todd Blanche, who is now representing the president, former president. Always a pleasure, Judge Napolitano. Appreciate it. Good to see you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.